it's Lisa from Been There, Got Out, and today is part 2 of our interview with Stephanie, Steph, the New York attorney, and we started this conversation a few weeks ago about the myths and realities of family court, and so we're going to continue, and I'm so glad that she's that she's agreed to come back. I feel like the last couple of interviews we do, sometimes we don't finish the conversation, so we have to keep continuing. You know, we have to schedule again, and Stephanie was busy and I was busy, but luckily she's coming back today. Let me just see if she's here.
Hi.
Hi. I was just saying that there's that conference, I forgot what it's called, but that I might actually get to meet you in real life in a couple of more months.
I know, I'm excited. I don't actually know if I'm going to be there in person or virtually, but I'm hoping that I will get to be there in person and see you.
Yeah, that'd be so neat. All right, so I was just saying thank you so much for coming back. We started this active conversation about the myths and realities of family court a few weeks ago. I don't remember when. But anyway, so because we sort of ended it, and I want to not say the exact same questions, but touch on some of the things that we talked about before, because it's always helpful for people watching now and for people that watch later. So before we even start, for people that don't know you at all, because you're like this TikTok superstar and we're on Instagram, but why don't you introduce yourself, your background, and say, what is a DV? What is a domestic violence attorney? Because people are like, I need an attorney that specializes in domestic violence. Nobody knows how to find you guys. So what are you? Tell us about your background, how you got into it.
Yeah, so hi everyone. My name is Stephanie. I am a domestic violence attorney. I'm based in the state of New York. I have been a DV attorney for a number of years now, but it was actually not the plan. I sort of just kind of fell into this field in this position, but I'm very happy to be here. I've come to learn over the years that it's a really good fit for me. I think that there are two different types of DV, domestic violence lawyers. That being civil versus criminal. There are absolutely lawyers within DAs and prosecutors' offices that specialize in domestic violence and sex crimes. And so I would say that is the one sphere of DV lawyers. And then there's my sphere of DV lawyers, which is the civil sphere, but we often blend into criminal because we do a lot of criminal accompaniment and we do a lot of criminal working alongside the district attorneys and helping on their cases. We're typically at nonprofits, whether that be like a legal aid or a legal services program, or it be a specifically named DV nonprofit. They're all over the country where that is their focus. And so I think I said this in the last live, but I will say it again. womenslaw.org has an option for you to search for domestic violence lawyers by your state and by your county in your state.
Yeah, and that's really helpful. We've given that link out to people. And even though it says womenslaw.org, it's not only for women, right? Like
Correct.
Men can use those resources as well.
Anyone can go on and use it.
Right. Okay. So one of the things that we also started talking about in sort of the title of this is some of the myths and realities of family court. And I'm thinking I'm going to name a couple of myths for you, or well, you tell me if it's a myth or not. I think it is. Or why there is some truth to it. So this is stuff that we hear all the time in this community. Number one, judges are completely biased. True? Not true?
I mean, judges are always, every person ever is biased. Judges are biased, attorneys are biased, juries are biased. Absolutely everywhere, everyone has bias. But I do think there are a lot of misconceptions about what that bias is and where that bias comes from and how that bias plays out.
Yeah, I mean, both sexes seem to feel like men say that judges are biased against them in family court, and women say the same thing, that they're not heard. But do you notice any patterns? Do you think there's anything to that?
You know, you may or may not have seen that I answered this in a video just a few days ago.
No, I didn't see it. Let's hear it.
I get many comments from men stating that they are at a disadvantage in family court, and just statistically that is not true. If you look at the history of DV from the beginning, the history of family law and custody and family court, you know, historically women and children were property, and so women did not have any rights in court. There absolutely was a time in US history where a lot of states' default custody laws were children always go to the mother. Those times have changed. Those laws are incredibly outdated. And most states have the default 50-50 standard right now. There are absolutely problems with that as well. But if you look at statistics, and there are so many studies on this, statistically, women do more often than not have primary custody of children, but that is because they more often seek it. However, if you separate the cases where men are actually requesting primary custody, they more often than not succeed on that claim. So if you want to get into the numbers, which I think sometimes you have to, that's the only way to answer some of these questions. Women are often at a disadvantage in family court, but statistically also, and this is not gender specific, people who claim domestic violence are often at a disadvantage in family court and will often not succeed on what they're requesting.
Yeah. So it's tricky. All right. Next one. All right. This is the big one. I will have my day in court. I am going to tell my story. I'm going to have all the time that I need. I have my big speech prepared, and the judge better validate what I'm saying and believe me.
Yeah, myth. For many, many reasons. I think first and foremost, a lot of people think that they will take a case all the way to trial and get up on a stand and testify. And you absolutely have the right to do that. You have the right to a trial in your case, but the majority of cases do not go that far. And the majority of cases settle, especially in domestic violence cases. That's because it is incredibly traumatic to go through a trial. You also have appearance after appearance after appearance leading up to trial, and people get burnt out. And they just say, I'm done, I can't do this anymore, which is completely understandable. And so one reason that that's a myth is because it's just never going to get to that point because of all the time and energy and effort that it takes. But on top of that, like you said, a lot of people think I'm going to take the stand and I'm going to give a speech and the judge is going to hear everything I have to say. And the reality is there are so many rules about what you can and can't say in a courtroom. And most people don't get to say everything that they want to say and think that they have a right to say.
Right. And there's also the time factor. People are on a clock. We often say we know judges that have 1,000 cases at a time. Like they just don't have the time to listen to the speeches, even though we want to tell the speeches. It's hard to be cut off.
It's so hard.
Yeah. So that's really hard. Okay. What about, this is a big deal, false accusations. So people say, my lawyer is going to address all those accusations, so I don't need to worry about it.
We absolutely will try, but the reality is in the sense that non-attorneys are limited in what they can say in court. We as attorneys are also limited in what we can say in court. I think I touched on this last time, but per the rules of the courtroom, no testimony is actually considered until you get to the point of a trial. So you're going to have these like appearances and settlement conferences leading up. Nothing that's said during those is considered as evidence. It's one of the rules of evidence because, people didn't take an oath. They're not on the witness stand. Their evidence is not going through the admissibility process that it has to go through in a trial. And so oftentimes, it very much depends on the other lawyer, and it very much depends on the judge that I'm in front of, because some judges absolutely do not want to hear it. But I've been in court time and time again where there is an opposing party or an opposing attorney spouting out all these false allegations about my client, and I don't respond. And that's because I know that this judge is already getting pissed off listening to all the talking, knowing that none of this is evidence and there's nothing they can do with it. And I'm not going to make the judge mad at us also by responding when every one of us knows that none of this is evidence.
That's actually kind of comforting because I think we all are terrified. Like when I see a motion that's filed that contains false statements, I freak out because I'm like, this is going on the record, but you're saying it actually doesn't matter until it's part of an evidentiary hearing, right?
Yeah, I mean, legally, it's not considered evidence until it's gone through the admissibility process. And furthermore, the reality is some judges don't actually read the motions that are filed until you show up and they're scheduled for an oral argument. I've had plenty of cases where I showed up and the judge didn't even know the basis of the motion because they didn't want to read it until we appeared and did it out loud in front of them. And yeah, so it's very scary to get this stack of papers that make all these allegations that are not true. But they have to prove those allegations, and they're not proven just by writing them on a piece of paper.
I want to take that statement and turn it into a post because I can't, I mean, I'm sure you know how terrifying it is for people to see in writing things from their ex's attorney accusing them of being an unfit parent, accusing them of all kinds of addictions and terrible habits, which they've never done, often projections of what an abuser is doing onto a targeted victim. And people are like, just, oh my gosh, like we have to address her. It's the judge is going to believe it. And because they're putting it out there, like I'm already going to lose the case and this is so awful. And how are we going to get out of it?
Well, and you know, a lot of the times that's the intent. A lot of times people are filing motions knowing that they're probably not going to succeed on those motions, but it's a tactic. And there absolutely are people who see these motions and think, this is too stressful for me. I can't do this anymore. I'm withdrawing my petitions. And so oftentimes it doesn't really matter what's in the motion if it does its job in scaring the other person into dropping out.
Exactly. And it's like that post-separation intimidation. So the intimidation that happened in the relationship, if you don't do what I say, I'm going to make you do it somehow. So then it transfers to the legal system where their own lawyer or the opposing lawyer is bullying and terrifying you into just saying, I don't want to deal with this. I'm going to look terrible. I'm going to give up. Yeah, absolutely. Well, that is very comforting. So
Good.
thank you for reminding people, everybody out there, remember the false allegations have to be proven. Mm-hmm. So try to keep breathing, even though it is scary to see that stuff on paper. Okay, another big thing that comes up all the time is at the very beginning of a divorce or separation, I'll just say divorce, one person says, I am going to get primary and legal custody because I've done the most work with the kids. Mm-hmm. Can that be true, or is that a myth?
I mean, what you're talking about is primary caretaker, which absolutely is a legal standard and often is a very large basis for who gets the children, you know, who does the day-to-day work, who takes them to school, who packs their lunches, who goes to doctor's appointments, who makes the doctor's appointments. That very much is one of the biggest factors in deciding who gets what when it comes to custodial time with their children. It's absolutely not the only factor. You know, I think especially you see especially in a lot of abuse cases, you see situations where a person was prevented from being able to fulfill those duties. You know, someone who wasn't allowed to use the car, so they couldn't drive the kids to school because they were prevented from doing that, or who wasn't allowed access to any bank accounts, so they couldn't write the checks for the kids' school lunches. And so absolutely that's going to be taken into consideration. I do think those primary caretaker roles are one of the largest factors in deciding custody, but absolutely that does not make or break a custody case. And it does not, that's not the final decision. That's not at all that it's based on.
Yeah, because I think people that we see all the time say, I want to get full, like at the very beginning, I'm going to get full legal decision making. And they think that that's easy.
And
that's not easy. Right?
I think the majority of people come into my office wanting to get sole legal custody. For those who don't know, physical is who has physical time with the children. Legal is who's making legal decisions about the children, where they're going to school, what doctor they're seeing, if they're going to have certain medical treatments, etc. And it's very hard because the law, I mean, the de facto law is joint physical custody and joint legal custody. And so if that's not what you want, you have the burden of proving that it should be something other than what the default is.
All right. So that leads me to like what things actually influence. So at the beginning of a case, a judge doesn't know you, you're just separating unless you have some strong history of patterns of behavior over time to show why that person's incapable of making legal decisions for the children. They probably won't get it. But let's say it's after the divorce, they have their orders and they come back 2 years later. What kinds of things do you think might impact a situation where somebody can move towards getting sole legal decision-making?
Yeah, so if you're talking an order already existed and now we're looking to change that is
right.
A different standard whereby you have to show that circumstances have changed since that order was issued. You know, and often when we most often see that, it's because the other parent in, you know, my work where I'm doing DV work, it's the abuser parent is refusing to cooperate and refusing to work together to co-parent for this child. And so often it'll be missed parent-teacher conferences or missed doctor's appointments where there's a record that this person didn't show, or it will be I'm thinking of a case we just filed actually where luckily this person had a very weeks-long email chain where the abuser was stating, I'm not going to cooperate. I will not sign these papers. I will not attend this appointment. And so as difficult as documentation is to get, and that rarely exists in DV cases, when it comes to legal custody, which is very hard to argue in comparison to physical custody, it often does come down to, do you have records of missed appointments? Do you have records of them refusing to sign certain paperwork, permission slips from school, doctor's releases, etc.? Do you have texts or emails or written conversations where this person outright states, I'm not going to do this, or where they've ignored every form of contact and you have a chain of unanswered texts or unanswered emails about important medical issues?
Yeah. I'm thinking also of a particular case that we have where one parent has mostly primary physical and has not brought the child to school for weeks, not consecutively, but weeks and weeks and weeks. And it's like, our client has sent communication and the other parent just keeps making excuses. And so we've been saying, no, I think that this person is building a really strong case to get more legal decision-making, because the child is missing so much school and there's really no reason for it.
And it's hard. And I think the cases where someone has sole decision-making often is situations like this, where they were not initially granted it and had to start off with joint and then show over time that was not going to work.
Yeah. Oh, can you still hear me? It just did a cycle thing.
Oh, I can hear you.
Okay, good. Okay. All right. So another thing is that a big complaint we hear is that judges don't believe people claiming abuse. So why is it hard? Why is it so hard to get sympathy? And I'm not asking for myself because I already know. But I want you to tell everybody, why don't they care? Why don't they sympathize when you go in and talk about how abused you are?
This is like the hill that I will die on, which is there is no training in the legal system. I, as a domestic violence attorney, did not have required training. Where I work now was sought out because I had prior DV knowledge, but there is not required training for lawyers, for judges, for court personnel to understand the intricacies of domestic violence, and that's so important. And so you very much get in front of a judge and have a DV victim who is presenting what you and I would know are signs of years of struggling to co-parent with an abuser, and someone who doesn't have trauma-informed training, who doesn't understand domestic violence, sees, oh, this person's petty, oh, this person's being difficult, oh, this person wants to be in control, and so that's why they think they can say this person shouldn't have visitation. And it's just a lack of training and a lack of understanding. And I also think, lack of experience. For me, starting out in the DV field, absolutely, it was learning from watching these cases and listening to these people, and that just doesn't happen.
Yeah, one thing that we deal with a lot when we're working with our clients is presentation. And we say how often they're up against a manipulative con artist who has no conscience and is very comfortable lying, and they're presenting as very emotional, which can often be used against them as look at how this person is so unbalanced and they must be an unfit parent because see how, they're falling apart on the stand. Well, we know why they're falling apart on the stand.
Yeah.
And the other person is so calm because they've been practicing lying for most of their lives.
And that's
very tricky.
Abusers are often incredibly confident, and so they come into a courtroom looking exactly how a judge wants, and frankly how juries. As we see DV cases in the media, there's so much commentary around how people expect a victim to look and how they're not believed if they don't behave the way that we want them to. So it's just lack of understanding and lack of knowing. And if we can get some laws on the books, I know that you know that we have one proposed in New York right now that would mandate DV training for judges. And if we could get those going, I think we'd see a big change in the family court system.
Yeah, and it's exciting. All right, so until we get those laws in the rest of the world, how can people make their abuse case more credible? Like, for example, a restraining order. Are there things that, I mean, I know what we think, but let's hear it right from you. If somebody's going for a restraining order, what makes them have a better chance of getting it? Like what kinds of documentation or anything you could say, any tips?
Yeah, so I'm going to say some of the very basic information, which is photos, text messages. If they're verbally and emotionally abusive, we often have a lot of text messages that establish that. I just argued a case the other day for a 5-year order protection, and in New York State, you have to show aggravating circumstances for that, which often is physical evidence of harm. And so what is difficult for people is they were hit or they were punched or they were strangled, but they didn't take photos of the physical evidence. And so they don't have proof that there was any harm done to them. Photographs of that is really, really helpful. While police reports are often not admissible, I do think that judges see a witness as more credible if they did call the police. There's so many justifiable reasons why people don't do that, and I don't think that should be an expectation, but absolutely there are judges who think if they didn't call the police, it couldn't have been that serious.
So you said police reports are often not admissible?
Yeah.
Why is that? I'm surprised.
Yeah, so, well, first of all, they're hearsay. They're an out-of-court statement. A lot of times, right. Yeah, I've had officers come and testify in cases, and that's how you get over that. You just have them testify about what they witnessed and what they saw. But there are rules of evidence. They vary by state. If you look at the federal rules of evidence, they state that you cannot use police reports against a criminal defendant. Per the hearsay rule, that's one of the hearsay rules. It's the public records rule. Yeah, so depends on where you are because the rules are different everywhere, but they're not always admissible. Also, I don't know if I'm sure you've read police reports. They are often illegible.
They type ours. I always get copies.
Oh, they type. Okay, they do not type them here.
Oh, no, here everything is typed and very, very clear.
I was going through a handful of them today for a client of mine, and it was like the both of us were sitting there trying to figure out what they said because we could not read them.
Wow. What about somebody just asked, are orders of protection admissible? I would think so, right? Admissible?
If you're talking, yeah, I mean, it's a court ruling. So if you're talking like, is an order of protection admissible as evidence in a custody case? Yeah, we use them all the time. A lot of times, what we try to do is, well, often those cases are going to be heard together. If you're filing a family offense petition and a custody petition in family court, they're going to be heard together by the same judge. What we do try to do, though, is have the order of protection trial first. So then you have a finding that can be used in the custody case, but absolutely use the fact that there was a finding of DV in your custody case because it's a court order. And so statements in court are not hearsay.
Yeah. And then I was going to ask, what about medical reports? Like your own, so say you get hurt and you go to the doctor. And so you talked about having pictures, but then is that hearsay also?
It can be, it may not be. The best thing to do is to have your medical records certified. That's what we do a lot. Because that gets over, you have to prove first that your piece of evidence is admissible, meaning it doesn't violate a rule like hearsay, and second, that it's authentic. Having it certified proves that it's authentic, and it's not something I went home and typed up on my computer. So that's really helpful. There is a rule about statements for the purpose of diagnosis that is a hearsay exception, and it's a statement you made to get a diagnosis can be admissible. So if I said, if I was a DV victim who had been strangled and I went to the doctor and I said, it's tight around my throat, I'm having trouble breathing, I'm coughing, those are statements made for the purpose of a diagnosis. And so those are not hearsay per that, or an exception to hearsay per that rule. Where it gets tricky is the diagnosis itself does not fall under that rule. So the doctor saying, oh, you have you're experiencing the effects of strangulation, that doesn't fall under the rule. But what I reported does.
Interesting. This is really fascinating and important. Like, I know, really, really important. Okay, so before you just talked about how sometimes, I know in California too, the order of protection does affect custody, but does abuse matter if it comes to child support? Because we know usually they separate money and custody stuff.
Yes. In New York, it does not. In most states, it does not. There are some states where it does. In the majority of states, whether you were a victim of abuse, whether you were a victim of adultery, those things do not matter to child support. You pop numbers in a calculator, and that calculator gives you a result, and that's your child support amount.
Okay, and that makes me think of the other question, which is people saying, well, if that person didn't pay child support, then they shouldn't be able to see the child.
Mm-hmm. Yes, this is another topic I've discussed recently. A lot of people think that I don't want to file for child support because that will get them custodial rights, and that's not true. Paying child support does not mean you have a right to see your children, because children are not for purchase. There are plenty of cases. I had a case a week ago where this abuser was ordered an order of protection to stay away from their victim and all of the children. That person is still paying child support because they're a parent. They brought these children into the world. They're financially responsible for them. But because they put their safety at risk, they're not allowed to see them. And so they're two separate issues.
Yeah, I'm so glad you said it. Of course, I'm not going to discuss my own case, but it's resonating with me. Yeah, and I think a lot of people get resentful because they say, if I'm paying child support, I should be entitled. And also that comes back to accountability. Like often when there is a court order that says you're not allowed to see them, or there's other reasons why it's there's usually some kind of lack of accountability involved.
Mm-hmm. And it's something that judges very much do not stand for. I've had so many appearances where in support court, someone will say, oh, she won't let me see the kids. And the judge says, take it to custody court, not my job. Or I had someone last week in custody court say, well, I bet this person's only making these claims so that I'll pay child support. And the judge was like, I don't care. I'm ordering custody and visitation and order of protection. Deal with your child support issues in child support court. It doesn't have any effect on me. Yep.
Okay, and then another big thing is child protective services, and the different states have different acronyms for it. But there's always lots of issues with that. Often people have, I'll just say DCS involved with situations and it goes nowhere. And then there's other cases where one of the parent reports the other parent to Child Protective Services. So do you have any tips on that? Because we've been told that it should never be one parent reporting the other directly, that it should go through an attorney or a mandated reporter, because it makes that person look bad if they do it directly. I don't know if you could speak on this, but if you can, just.
I can't tell people what they should and shouldn't do, but I can say we as attorneys are rarely the people making those reports. I didn't witness it. I'm not in the home. I'm not seeing what happens. And so I don't think that I'm the appropriate person to do that. But to what you said earlier, it is true that the majority of reports made to CPS or DFS or whoever it may be do not go anywhere. And so I frequently have at the very beginning of a custody case, one parent just constantly making reports against the other parent. And the reality is in the long run, they often just end up getting closed and nothing happens with them. And we've seen so many cases where that shouldn't have happened and a child ended up getting harmed or worse. But yeah, to answer your question, I don't know that there is a right answer. I think it's very situation dependent. Who should be the one to report, if a report should be made. I don't think there are very few situations where I would be the appropriate person to make that report. But regardless of who's making it, more often than not, it's going to end up being labeled as unfounded and closed.
Right. And do you think that can often be used?
My doorbell.
that can be used. We've seen that used against victims in custody cases where they'll say, this person opened a case against me and it went nowhere, and therefore that person is just harassing me. Like, is that something that people should be worried about? Because we've seen it kind of weaponized occasionally.
You know, I see it weaponized, and it's really hard to get anything done when it's been weaponized unless it gets to a certain point. You know, it's been done X number of times. If it's been like 4 or 5 reports, we often can't do anything about that. But I've absolutely had cases where it's like dozens of reports. And what we do in a lot of those cases is ask that the court order that this person be required to seek leave of court in the future, should they want to make changes to their family court case. And that means that we can't trust this person to be responsible and only open court cases for situations where a court case is deserved. And so should they want to file in the future, they need permission to do so, because otherwise, you know, every person has the right to file a petition if they want to.
Right. And there's all that frivolous litigation where people, you know, one of our things is legal abuse, or vexatious litigation, where people just keep filing motion after motion and dragging a victim back to court with time and money and energy, and a lot of it is unfounded, but that's how they weaponize the judicial system too.
And it's so hard to prove abusive litigation, because there's an endless number of reasons why a case could be delayed, or why a new case could be filed, why a new violation could be filed, and it's so hard to prove that this person had bad intent in doing so, and there wasn't a justifiable reason to delay, and it absolutely is weaponized. And you know, my answer, I wish I had an answer that was, here's how to stop someone from doing this. You really don't. Everyone has a right to file petitions in the legal system. It's a constitutional due process right that they have. My answer is, that's why I try so hard to let people know that there are access to free legal services out there, especially for abuse victims. So at least they're not paying for it, you know, at least they're not paying for their lawyer to have to go to court every time this happens. I wish I could do more than that, but that's kind of the best that I can provide.
I know. And again, so they should look at womensaid.org, or sorry, womenslaw.org to find some of those free resources. Okay. Here's a controversial one: defamation cases. After the big case that just happened, another attorney I had asked, he said that he thought that was almost a unique situation, because the two parties were celebrities, and it really did have an impact on somebody's career, because it was so public. And he said that he didn't think that would really affect the average layperson. But what do you think about the whole defamation thing being used against victims?
I don't think that, absolutely, we would not have seen that case in the light that we did, was it not the focus of 2 white celebrities. Do I think that other defamation cases will get that kind of spectacle? No. But I absolutely, and I don't just think, I know, because we're seeing reports on top of reports of the fact that this case absolutely has encouraged people to at least threaten to file defamation cases. You know, I've had this conversation with people from multiple DV agencies. We've had nationwide DV agency meetings where so many people are reporting that they are having victims coming to them saying, I'm being threatened with a defamation suit, or I got served with a defamation suit. And so, you know, I think it would be lovely to be able to say they're celebrities, it's not going to happen to our clients, but the reality is it is happening to our clients, and we're seeing. And it doesn't even have to, I've said this before, it doesn't have to be a suit. It can be the threat of a suit, and the threat of bringing someone into court is often enough to silence them. And so abusers don't have to go any further than that. They know that we've now all seen what having a defamation case can do to a person, and the threat's going to be enough to make someone stay quiet. And so I would love to say that it's not going to have an effect, but I absolutely think it will, and it already is. Yeah,
what you just said makes me think of a quote. One of these, we interviewed a guy named Steve the Bodyguard, who's also really involved with domestic violence nonprofit in New Jersey. And he said that an abuser's greatest tool is the ability to instill fear.
Yeah.
And so that's exactly what you're describing. It also made me start thinking in terms of defamation about, and this comes up all the time, posting your situation on social media. Mm-hmm. Do you think that that's something that people might use as the basis for a defamation case? Because say someone's on TikTok, for example, and has all these followers and they're putting their story out there. Because we've had clients who have put details of their things out there and it's been used as evidence in court and they've gotten in trouble.
Yeah. I would love to say that it wouldn't, because the basis of a defamation case is you can't succeed on the case unless what the person is saying is false. The reality is, though, defamation cases are being presented to a jury, and we can't always trust 12 strangers to be smart enough to know what's true and what's false. And so I'd love to say, as long as everything you're saying is true, it's not defamation. But the reality is, I'm not deciding if it's defamation, and you're not deciding if it's defamation. A jury of 12 people are going to decide if it's defamation, and they may very well not believe you. I wish we lived in a world where people could talk about their experiences and not have to face legal action for it. But the reality is, anything you post online can be used against you. It's not hearsay, because statements by a party are not hearsay. So anything that you state out loud in a text, in an email, on social media, absolutely can be used in court.
Yeah, and I think people should really be aware of that. I understand a lot of people, a lot of our clients and a lot of people in this community are like, I'm helping other people by sharing my experience. Not saying that you shouldn't share your experience, but you have to think, could this be twisted into something and used against you? Because we've seen it, fairly frequently, and enough to talk about it in these interviews to say, like, let me ask an attorney. And all the attorneys have everyone has said, be careful about that digital footprint, and not even just publicly, but in private Facebook groups. I interviewed a best-selling author about her book, and part of the story included a con artist who was using private Facebook groups to find vulnerable targets, vulnerable victims, because she was getting information about them and connecting with other people in their circle to get what she wanted.
I will say it does go both ways. I think abusers think that they can post whatever they want online, and
right.
They tricky, and they can use fake names or have private profiles. And the reality is, I am also looking for that information, and I'm also going through your social media pages and your friends lists. And so it does go both ways. But yeah, people need to be very careful about what they say online. And I wish everyone could share their stories, because it does really help a lot of people, but it also exposes you to liability.
I know. And Stephanie, I've seen some of your content where I don't know what you call it, like things I would never advise you to do if I were your attorney, and you show films of people stealing stuff who are posting it on TikTok. It's like,
so many people admit to committing crimes on the internet, and I don't understand.
Yeah. Okay. All right. Next question, coercive control. Do you think that this should be a criminal offense? Like, luckily in Connecticut now, it's part of like the family law and all that, but should it be a criminal offense?
Yeah. I'm so on the fence about this, because I've been listening to people who have been doing this work far longer than I have. And one of my direct supervisors is very adamant that it should not be a criminal offense, but I also work with a lot of people who are adamant that it should. I think it really comes down to, like, there's already so much policing in America. And also the reality is our police are not even policing the DV crimes that we have now. We're seeing time and time again, women.
Right, and it's one of the most common.
Absolutely.
Like in our town, it's the second most common crime.
Really?
Yeah.
Yeah. And, we're seeing women end up dead because they were making reports of stalking and of harassment and even assault, and nothing was happening. No criminal charges. Oftentimes, a lot of people are sent to family court and no criminal charges are pursued. And so I think, it would be great in theory to have coercive control, which is one of these forms of DV that we often don't see represented in the law as a crime. But we're not even seeing general DV policed right now. We're not seeing physical DV, which is the most believable form of DV policed. And so I think coercive control laws are great. Absolutely. It's not a recognized enough form of DV, and we need them on the books. We really need them as family offenses, which is what New York is heading towards. I don't know if making it a criminal offense is right. I think more so what we need to be focusing on is training our police in domestic violence and trauma, and training them on recognizing signs of domestic violence and policing those instead of policing some of the policing poverty and things that they tend to focus more on.
Yeah, well, and that leads me into the next question is about, so of course it's important to educate all these professionals, but judges decide themselves what education they get. So how can you educate people who might not be interested in learning and are kind of untouchable in my eyes?
Yeah. I mean, one way is you mandate it, which is what we're trying to get passed as a law in New York State, that DV training for judges be mandated. I think another way is it falls to us as attorneys to explain it. And I don't get to testify in a trial. And so that's, I think, more so my job in those conferences leading up to trials is to explain the circumstances to the judge and explain domestic violence to the judge and explain, this person is afraid of leaving their house. This person has had to change their phone number 3 times. They may not have acted on it, but threatening to take someone's kids away from them has a serious effect on people and has a really, and teaching these judges, when this victim responded that way, that was the effect of trauma. That was not a refusal to co-parent or being petty or being over dramatic. That was the effect of trauma. And we just kind of have to force it on them. I know that's doesn't seem like the kindest answer, but I think it's just on us as attorneys to put it out there until we have laws requiring it, because there's no one else who's going to do it if not those of us who are standing in front of the judge with the opportunity.
You actually gave the exact same answer as Evan Stark did. He's the author of the book about coercive control.
Oh, yeah.
I was at a conference with him, and that question was posed to him, and he said exactly that. He said the only way that we're really going to educate the judges is getting before them and presenting stories that they could understand, so they start realizing what coercive control really looks like. So it's really up to us to educate them through our testimony.
I also think it's electing better judges. I think we do a lot of, this isn't news to anyone, but we do focus a lot on who our presidential elected officials are and who our congressional elected officials are. But when it comes to these smaller local judges, and, family court is county by county, these are not people who are running to represent the entire state of New York or the entire Northeast, whatever it may be. I don't think we really do a lot of research into our judges, and we should, because they're making decisions that affect a lot of your community.
Significant ones, and your family, and your children. Like, what more important thing could you be focusing on? Yeah, that's good. It's good to remember that, and I'm going to put that in our little post as a highlight of what we talked about. Okay, so I think, unless there's anything else you want to say, Stephanie, I think like we finally finished the myths and realities of family court. Not that this is going to be our last conversation, hopefully.
No, I think I'll just circle back to what I said before, which is, because I've even since we last talked, I've had this conversation so many times, that the biggest myth is if I'm a DV victim, I get to call the shots in family court. And I wish that were true. I have so many people who come to my office and say, I'm a DV victim and here's the schedule I want, and think that we're just going to go into court and that's what's going to happen. And the reality is typically the default is going to be 50-50, and we have to do a lot of the work to change that. And it's not going to be show up in court and start with what you want just because you claim to be a DV victim. Absolutely, victims should be believed, but that's not reality right now.
Right.
So I just try to be as upfront with people as possible so they're not blindsided when they walk into a courtroom and don't get what they want. So yeah, I just think people need to know it's an uphill battle. It's not as easy as alleging DV and then starting with the upper hand.
Right. And it's important to realize that even though this needs to happen, or this should happen, or why is it like this already, it's just not.
Yeah.
And we're both New Yorkers, and Chris and I always call it the Heart of New York reality show. It's not. So now, knowing that, let's strategize. Let's figure out what we can do to operate within that system. Absolutely. So that you are empowered enough to hopefully educate a judge to understand. And another thing people need to realize is often it's not just in one appearance that a judge is going to get it, right?
It's never in one appearance. It's going to be multiple. And yeah, so many people come in saying, oh, we'll be done with this in a couple of months, right? And I have to prepare them for the reality that it could be 6 months, it could be 2 years.
or more.
Yes, absolutely, or more.
Yeah.
Divorce.
Yeah. Okay. So I know, Stephanie, you're part of, we don't know, and it doesn't matter what group you're with, but how can people find legal aid or people like you, either in New York or in the rest of America? I don't know if you have any resources because we have international people on here as well.
Yeah. Yeah. So my first answer is always go to that womenslaw.org. But the other answer is most counties in New York State, every county gets Office of Victim Services domestic violence funding. And so there's an organization in each county in New York that is tasked with providing DV services. That's not always a legal organization. Where I used to work, it was not. So actually, the organization that was granted that money then contracted with us to provide the legal services for DV victims. But in most states, there is state funding for each county for a DV services agency. Often that's going to be the YWCA or Catholic Charities, some kind of non-legal nonprofit. But they know who the DV lawyers are and they can point you to them. And so they're usually providing DV advocacy services. Often it's the organization that runs DV shelters in the area. And so if you don't know how to find a DV lawyer, find a DV advocacy organization, which you can Google, and they will tell you who the DV lawyers are.
Oh, that's great. Very helpful. Okay, thank you. All right, Stephanie, thank you so much for coming back, and we'll come up with another topic for another time because there's always so much to say about this.
Absolutely. I'm ready for it.
Good.
Thank you for having me.
Oh, my pleasure. All right, everybody, thanks for coming, and see you soon, Stephanie.
Bye.
Bye.